Welcome back to Good Law, Bad Law. Did you know that the insanity defense dates back to the 1300s in English law and has been a part of American criminal law, for up until the last few years? My guest on today's episode is Professor of Law, of Criminal Law at the University of Pennsylvania, now the Carey School of Law, Professor Stephen Morse, also who was my criminal law professor back in law school. And Professor Morse has co-authored a brief to the U.S. Supreme Court in a case coming out of the state of Kansas, which is now trying to make, against the law, the bringing of the insanity defense in any criminal case. What is the insanity defense? Can you be held criminally responsible for a crime, even a very violent crime, even murder, if you were so not in your right mind, if your level of rationality was so impaired that you didn't know the consequences of your action, you couldn't appreciate right from wrong? That's the issue in this extremely important case. And Professor Morse is one of the country's leading experts on the insanity defense. And we have a really, really fascinating conversation. I know you're going to learn a lot and enjoy the chat as well. Stay tuned. On today's episode, we're going to be discussing the insanity defense and the state of Kansas's abolition of the insanity defense altogether, and an appeal to the United States Supreme Court challenging that. With my guest today, Professor Stephen Morse of the University of Pennsylvania Law School, co-author of a brief to the Supreme Court challenging the Kansas law that has abolished the insanity defense. So first of all, Professor Morse, Steve, thank you so much for being on the program.
Thanks so much for having me.
Before we get into this topic, I have to say this, that you were my criminal law professor at Penn Law School, and that was a number of years ago.
It was a while.
But I had to share a funny story because I was thinking about meeting you again after some years. And most people who have not been to law school don't know about the terror that first-year law students face. Though they may have seen this depicted on television. But I have such a clear and distinct memory of my first day of criminal law in your criminal law course. Thankfully, I wasn't the student called on, but we were expected to have read a case in our casebook before the first class. And the very first question using the Socratic method that you asked of a poor, unsuspecting first day of law school student was, "Who is Regina?" And that's because the case was Regina versus somebody, I don't remember who the defendant was. And the poor student...
Dudley and Stevens.
There you go. And the poor student didn't realize that this was a case from England and Regina was the queen.
Yes.
So thank you for that memory. For our listeners, give us a little background on yourself. And I know that the issue of intention, the ability to form an intention to perform a crime, and in particular, how that affects those who are mentally impaired, has been a big part of your research and your writing over the years. But give us some background on yourself and how this issue has been of great interest to you over the years.
Yes, well, in addition to being a lawyer, as you know, I'm also a psychologist, and I'm a board-certified forensic psychologist. So since I actually began my professional career as an academic, which was a very long time ago, I've been consulting as a lawyer and take cases as a forensic psychologist. I've always been interested in what I call the human law package, basically crime, people with disorders, kids, as opposed to the money law package, corporate law, things like that. So I've been working on these issues and working on mental state issues more than anything else over the entire course of my career. And the question about mental disorder and criminal intent is actually much more straightforward than people think. People who have severe mental disorder, and for all intents and purposes, unless someone suffers from a severe mental disorder, something like schizophrenia or a major affective, that is feeling disorder like major depression, they're not really going to have any excuse to crime. The relation between severe mental disorder and the ability to form intents is just like your ability or my ability. So, for instance, if I were to ask you, why are we in this room together? We would come up with an explanation, something like this. We desire to do this podcast. We believe that by sitting here together with the appropriate equipment, that will produce the podcast, and we form the intention to be here, and here we are. Mm-hmm. Well, if you look at the really important insanity defense cases, there's no question that the person formed the intent that meets the definition of the crime. So let me give an example to make it clear, especially for your non-lawyer listeners. The most famous insanity defense case in the English-speaking world is, of course, McNaughton's case from 1843. Mm-hmm. Daniel McNaughton suffered from what we would call today either, it's a little bit unclear, paranoid schizophrenia, or he suffered from what's known as delusional disorder. McNaughton really believed that the reigning Tory party was engaged in a plot to kill him, and they were persecuting him.
This is in England.
This is in England,
yeah.
and this was clearly delusional. And for those who aren't aware of the technical meaning of the word delusion, delusion is a firm, fixed idea that is out of touch with reality and that is absolutely proof against argument and evidence. People who have these firm, fixed ideas, things that are just simply not true, and they can't be convinced otherwise, no matter what your argument is, no matter what the evidence is.
So they're not susceptible to reason.
They're not susceptible to reason. That's a perfect way to put it. Mm-hmm. So because McNaughton was afraid that the Tories were going to kill him, he formed the intent to assassinate the Tory Prime Minister, Robert Peel. And he learned Peel's route to go in his carriage to Parliament and things like that. Mm-hmm. He purchased a pistol, and he was right by the side of the road. Peel's carriage went by, and he intentionally shot the occupant of the carriage. Now, it turned out not to be Peel. It turned out to be Peel's private secretary, Drummond. But as the lawyers listening in know, if I intend to kill person A and I miss and kill person B instead, I'm guilty of the intentional killing of B. Right. So he was tried for the murder of Drummond. And there was no question he formed the intent to kill just the way you or I might form the intent to kill. He desired to save his own life. He believed the way to do it was to kill Peel. And he formed the intent to kill Peel, and he did. And if you look at all the famous insanity defense cases, they're all like that. People who are so crazy, who are so out of touch with reality and sort of omni-disorganized and completely disabled in their life skills, they typically don't get involved in serious crime. They may do petty stuff on the street, simple assaults, or they may do petty thefts, and not even burglary so much. Burglary requires some planning and things like that. So, all right, so he's formed the intent to kill. What the insanity defense is what's known as an affirmative defense. And to understand what that means, you have to understand the structure of criminal law. Crimes are defined by what lawyers call their elements, their criteria. So murder, for example, is killing conduct, intentional killing conduct. So I can stab my victim, I can shoot my victim, I can poison my victim, I can bludgeon my victim. Formed and done for the purpose of killing. So you did it on purpose, for the purpose of killing your victim. That's what the prosecution's got to prove beyond a reasonable doubt. And in McNaughton's case, for example, it was simple. He clearly formed it was intentional killing conduct. He clearly formed the intent to kill Peel. There's still a way to avoid culpability in the criminal law, which is you raise what's known, as I said, as an affirmative defense.
Well, but before you get to that, though,
Okay.
I have a question about the intent part.
Okay.
Because we know there are certain people who, as a matter of law, are not competent. For example, a child is not competent to form a contract, and a contract made with a child is voidable because, legally speaking, they can't form the ability to accept in an offer and acceptance situation, or somebody who is so severely disabled cognitively, let's say, may have a guardian appointed by a court because they're unable to make decisions for themselves, say regarding their health or regarding their finances. Why doesn't mental disorder serve to negate intent based on lack of mental competence?
Well, I think the answer is that I would characterize your two hypothetical cases quite differently.
Okay.
Even a very small child may be able to make a deal, form the intent, I'll trade you my cards for your marbles or whatever. So forms the intent to make the deal. The reason we allow minors to void their contracts is not because they can't form the intent to make a deal, but because we think their capacity to really understand the full implications of what they're doing is impaired. So that's what we mean by incompetent. Not that you're not able to form the intent to do something, but you really don't understand very well the implications of it. And I think the same is true of people, let's say, with dementia, who may, let's say, need a guardianship. They now need medical care. And the doctor says, what I would like to do is treat you in the following way. And the patient clearly can say, I accept or don't accept. But again, they may, because of their dementia, not really fully understand the implications of what their acceptance or rejection of the medical treatment means.
So it really is a parallel then.
It is a parallel.
Because in McNaughton, he had the intent, he just didn't understand. And that's where you're getting to with it being an affirmative defense.
That's right.
Okay.
So there's been in English law some kind of affirmative defense since probably, some kind of insanity defense since about the 1300s, believe it or not. Every state in the Union until the late 20th century had an insanity defense, and the federal government also had an insanity defense. But here's what the judges said in the McNaughton case, because it went all the way to what was the Supreme Court of England, which was then a group of lords in Parliament known as the Law Lords. And they basically said, if the person, as a result of mental disorder, did not know the nature and quality of his act, or didn't know that his act was wrong, then he would have an excuse, even though he formed the intent to kill. So the notion being that, let's assume for the moment that McNaughton had an adequate moral compass, that there was nothing wrong with his moral sense, but he really thought he was in deadly danger, and he thought he was acting to save his own life. So in a very fundamental way, he didn't know what he was doing was wrong. He thought what he was doing was utterly justified under the circumstances. It sounds like self-defense.
Yeah.
Right. And so when we say that someone has an affirmative defense, what we mean by that is the prosecution typically is able to prove the definition of the crime, so murder, but because the defendant suffers from some disability, the defendant, for example, doesn't know right from wrong. And that's the problem. And what we know is that people who are severely mentally disordered often don't understand very well. Let me give you one more example. So some of your listeners may recall the case of a woman named Andrea Yates, who some years ago in Texas drowned her 5 small children to death in the bathtub.
Yeah.
This was clearly carefully planned, and she clearly intended to kill them. What she believed, and everyone, including the prosecution expert witness, agreed that she had a delusional belief that if she didn't kill the kids now, they would be tortured for all eternity by Satan in hell because she was corrupting them. They were still not so corrupt that they would go to hell, but if she brought them up any longer, she would corrupt them and they'd be tortured for all eternity in hell. So she thought better to kill them now and let them go to heaven than, in a sense, consign them to the tortures of hell for all eternity. Well, let's think about her for a second. Did she know that the kids were human beings? Yes. Did she know that holding them under the water would kill them? Yes, she did. Did she intend to kill them? Of course she did.
Yeah.
Did she know probably it was against the law of Texas to kill your children? Sure she did. Did she know that the neighbors would probably disapprove? They would think it's morally wrong, if not legally wrong. And she probably thought that too, but here's what she might have thought to herself. Suppose they, the neighbors knew what I know. And remember, it's a delusional belief, so we can't talk her out of it. That if I don't kill the kids now, they're going to hell and be tortured for all eternity. Well, are you a parent, Aaron?
I am.
Well, I'm not going to ask you what you would do, but just think about it for a second.
Thankfully, I do not have that delusion.
You do not have that delusion. You did.
And cared about my children.
That's right.
Yeah.
You might think to yourself, as awful as it is to kill my beloved children, better that I do that than they go to hell and be tortured for all eternity. Eternity is a very long time.
Yes.
Yeah.
And I want to get into some of the details of this case and and the importance of it, and what we think about how the Supreme Court will handle this based on other principles that they've already established. There's a lot of good material in that, but the insanity defense, I think there are a lot of myths about the insanity defense, and this is somewhat addressed in the brief that you and Professor Bonney submitted to the Supreme Court. One myth is how frequently invoked the insanity defense is in criminal cases. Two is how often it's successful, and also, and this is the one I want to start with, I think, what exactly it is, because I remember a very famous case where the insanity defense, or a variation on the insanity defense, came up. I was in high school in San Francisco when, over the loudspeaker, we were told that we were all dismissed for the day because the mayor of San Francisco, George Moscone, and city councilman Harvey Milk had been shot and killed. And the person who did this, I think in the popular recollection of what happened in his case, invoked what became disparagingly referred to as the Twinkie defense, a sort of temporary insanity.
Not really.
Okay, so that's what I mean. See, this is a myth. This is a misunderstanding of this. So maybe you could address that and what the insanity defense is and what it isn't.
Okay. The insanity defense is a complete defense to crime if it's successful. And by that I mean you are found not guilty by reason of insanity, and because you're not guilty, you may not be punished. Now, people who are found legally insane do not then walk the streets. In every jurisdiction in the United States, they are typically either temporarily or permanently committed to a secure forensic facility where they will be kept until they are no longer mentally ill or no longer dangerous. Mm-hmm. And although
if ever.
And sometimes that means they're going to remain in these institutions for the rest of their lives, right, which the Supreme Court has said is constitutional. Because if you are mentally ill and you are dangerous as a result of your mental illness, then you can't be safe to walk the streets. Now, it turns out that most people who are legally insane end up being incarcerated in these forensic hospitals for about as long as they would have gone to prison if they had been convicted of the crime charged. The studies on that are not excellent, but that seems to be the appropriate outcome, or the most frequent outcome. Mm-hmm. What you said to begin with is right. The insanity defense is very infrequently raised in felony prosecutions, virtually never raised in misdemeanor prosecutions, and it's even less frequently successful, although there's some variation from jurisdiction to jurisdiction. Okay, the Dan White case was a little bit different. That was the ex-councilman and police officer who had assassinated Mayor Moscone and Supervisor Milk. He was really angry at them for all sorts of reasons. He was a bad homophobe, and he had resigned from the city council. He wanted to get back on it.
Right.
And Mayor Moscone refused. So what White did was he loaded up his service revolver and took extra ammunition. He crawled into City Hall through a basement window because he knew about the metal detectors through the usual places. I forget whose office he went to first. He assassinated one, reloaded, and then went and assassinated the other. To explain this in great detail would take us another 3 hours, but the short form is California then had a judicially created partial mitigation. If you would otherwise have been guilty of murder, and for all the world, this looks like a premeditated, intentional, typical first-degree murder prosecution. But if you suffered from some kind of mental abnormality that prevented you from comprehending and being aware of your duty to act within the law, which actually sounds like an insanity defense, but it's not. Instead of getting convicted of murder, you would be convicted only of manslaughter, which is also a very serious felony, but a lot less serious than murder. Now, at his trial, what White claimed was because he had been depressed, that was why he couldn't comprehend and be aware of his duty to act within the law, even though he clearly formed the intent to kill the mayor and the councilman Milk. And his expert witness, a psychiatrist, said he had been ingesting a lot of sugary junk food, Twinkies, and that, in a sense, made his depression worse. So there really was no Twinkie defense. The Twinkies in this case was just evidence to help support his claim that his depression was so bad that he couldn't fully comprehend and be aware of his duty to act under the law.
Well, can depression we talked about someone like in McNaughton and the Yates case who is so delusional that they're not susceptible to reason. They can't be talked out of that delusion. Can somebody have a medical condition like depression that is severe enough that it renders them unable to appreciate right from wrong, that it could constitute an insanity defense?
Yes. Whether or not we call depression a medical condition really doesn't matter. What we're talking about is acting human beings and what their mental state is. Here's why you don't see a lot of depressed people in the criminal justice system for these serious kinds of felonies. Because if you're really seriously depressed, you tend to be apathetic and down, and you just don't have the energy to commit serious crimes. Any of the listeners who has experience with depression or knows people who've been severely depressed know what I'm talking about. These are not people who tend to be energetic and go out and commit serious crimes. However, people who are suffering from mania, where they have, in a sense, too much energy as a result of their mental condition, they may, because they're manic, be so out of touch with reality that they really don't know the nature, they don't know they're doing what's wrong. So, for instance, suppose I'm suffering from mania, which is a form of mental disorder, and I delusionally believe as a result that I have millions of dollars in the bank. And now I write a check that's a vast overdraft because I'm not trying to defraud anybody. I really think I have it in the bank.
Right.
In that case, I don't know right from wrong. So that could happen. But virtually all the cases you're going to see where an insanity defense is successfully raised, the defendant was either delusional, as we've discussed, and that was true of Ms. Yates, it was true of Daniel McNaughton, and it was allegedly true of John W. Hinckley Jr., who you will recall was acquitted by reason of insanity for trying to assassinate President Reagan and a bunch of other people, or they're suffering from hallucinations. Now, hallucination is a perceptual experience. It can be in any of the five senses in the absence of a stimulus that would cause that perception. So I see something that's not there, or the most frequent hallucination is auditory. I hear something when no one, let's say, I hear God's voice telling me to do something. And that's called, by the way, a deific decree. It happens enough that we have actual doctrine for it in law. I heard God's voice. God told me to do it. What, I wasn't supposed to listen to God?
Well, right. And so these are I guess what we're talking about is what are the conditions where someone credibly can invoke the insanity defense? Because you can imagine situations where somebody, I don't know if this is the right word, but fraudulently invokes the insanity defense. And I know that's another worry about the insanity defense, and you address that in the Supreme Court brief.
There's almost no evidence that people are easily able to fake major mental illness for these purposes. Typically, given their history, what their friends and family, co-workers know about them, there's it's typically pretty obvious that you don't have malingering in most of these cases. Now, I'm not saying there are no cases of malingering, but it's not a major worry. The insanity defense on the statute books in most states doesn't specify which kinds of disorders will support an insanity defense. But as a matter of statute in some places, and certainly as a matter of the court's interpretation of the insanity defense in others, unless the defendant suffers from a severe mental disorder, one that basically causes them to lose touch with reality, they're not going to be able to raise the insanity defense, or if they raise it, what we know from studies is they're going to lose.
What I'm thinking as we're talking about some of the mass shootings that dominated the news in the last several years, really starting with Columbine and right up to what happened in El Paso a few months ago. What happens in the political discourse after some tragedy like this is, well, this is a mental health issue, and I feel it has to be, of course, because somebody who could do something like that, shoot up a school or shoot up a movie theater or shoot up a Walmart and be, quote, in their right mind?
Well, I have to disagree with you.
Okay.
Because there are people who are twisted, there are people who are narcissistic, there are people who are grandiose, but they are in touch with reality and they know what they're doing. And I'll give you my favorite example of all of these. Anders Breivik, the Norwegian young nationalist who killed 77 people in this sort of mass slaughter in and around Oslo some years ago. And the question was whether or not he was mentally ill. And he wasn't. Now, the Norwegians had a very hard time with this case because they were very Pacific people, and they just didn't understand how one of their own could do something so horrible. But the final version of how to assess his mental state was that he was very grandiose and very narcissistic, and to use a sort of common sense term, he was twisted, but he wasn't out of touch with reality. And people who are twisted are responsible for themselves. And now it may be in some of these cases, and if the mass murderer is killed in the course of or commits suicide, then we'll never have a chance to examine them. But in a particular case, it may be true that the person was mentally ill. But the relation between major mental disorder and violent conduct is no greater than in the general population. People with major mental disorder are not dangerous to their neighbors unless they use substances. But then they're no dangerous than their neighbors who use substances. So now they're more likely to use substances than people without major mental disorder. The reason being, we think, because they're self-medicating to avoid the pain that is caused by their mental disorder. But as a general rule, people with mental disorder are not dangerous and don't need to be feared.
Okay, so I think now we're going to get into the aspect of this that's really my favorite part, which is what does this mean about how we view crime and how we view punishment and the purposes behind punishment? Because as you've pointed out, if anybody out there is imagining that someone successfully invoking the insanity defense goes free and walks the streets, that's not what happens anywhere under state or federal law. So it's not about taking someone off the street. So why then has Kansas moved to eliminate the insanity defense, along with only a very small number of other states who previously have done so? And I know this is going to be a very big question here, but why have they done that? Why do you think that's dangerous? And what is that? What do these opposing views say about the purposes behind punishment of crime?
Yeah. Well, in current United States and English thinking as well about the purposes of punishment, what people mostly say is punishment serves three major purposes. First, it serves the purpose of retribution. And this is a theory, and this is not revenge. This is not getting your bloodlust off. This is a theory of justice that says people should get what they deserve. And it's a theory of justice, of desert, not just in criminal law. So if two lawyers who are working for you are putting in the same hours, but one gets a lot more done than that person who's getting a lot more done, I think justly thinks he or she deserves a bigger bonus than his associate who doesn't do.
None of the lawyers in my office listen to this podcast, so that we're safe talking about this.
Fair enough.
I'm kidding,
All right.
They do.
So,
they have to.
So one of the things we are doing by punishing people and blaming and punishing them is we are giving them what we think they deserve. If you are a culpable, that is guilty agent,
Legally responsible,
then we try to give people what we think is the proportionate punishment. Obviously, homicide will carry a much greater punishment than trespass, for example. Okay, so that's one purpose. Then there are two purposes that are more concerned with public safety: incapacitation, taking people off the streets, and then we want to deter other people. By punishing A, B, C, and D will be afraid to commit the crime because they don't want to be punished either. Now, many people think rehabilitation or reform is a major aspect of criminal justice. It isn't at present. It was, at least in theory, 40 or 50 years ago, but since about the 1970s, retribution, deterrence, and incapacitation have been considered the major factors. Well, apply these now to people with severe mental disorder. At least in principle, these are people who don't know what they're doing or don't know what's wrong, so the law is not going to be able to deter them. As you suggested, we have ways of making sure that they are confined if they remain dangerous and mentally ill. So that leaves retribution, and that really goes to the core of the issue. Are people who are not capable of being guided by reason, as you have suggested, are these people responsible moral agents? And should the law be in the business of punishing people who are not responsible moral agents? So for people who don't really understand this very well or don't get it, here are two analogies. How come we don't punish children, blame and punish children who commit crimes much as we do adults? There's no mental disorder involved in most cases, but we think their maturity is yet undeveloped, so they don't understand the full implications. They're not fully capable of reason yet.
And don't know right from wrong.
And even if they do, they don't understand the full implications of knowing right from wrong.
Yes.
Obviously, as you get older in the adolescent era, your understanding and your maturity and your life experience increases your rationality. Now think about the other end of the age span. How about someone who is severely demented and assaults somebody else? Once again, we'd say, well, look, we may have to confine this person who has an assaultive form of dementia, but we don't think we should blame and punish that person because they are, again, not capable of reason through no fault of their own. Well, that's the argument about people with mental disorder, because no one thinks you're responsible for being delusional, assuming you're not on drugs or something of the sort. People who are really suffering from a mental disorder, a major mental disorder, it's not their fault. And as a result of it, if they don't understand what they're doing or don't know right from wrong and are not capable of being guided by reason, then we believe they don't deserve blame and punishment. And that's what the insanity defense does. Now, Kansas, Montana, Utah, and Idaho, which are the other three states, abolished the insanity defense because I think the legislatures of those jurisdictions had come to believe many of the erroneous myths about the insanity defense. People are beating the rap, they're walking out the door, but holding that aside, they weren't entirely insensitive to the influence of mental disorder. So what those four states, in one way or another, allow the defendant to do is to use the evidence of mental disorder to say, I didn't form the intent, for example, required by the definition of the crime. So here would be a really good example that actually went to the Supreme Court of the United States in 2006. it wasn't a state that had the insanity defense, but it's a classic example of the problem. Eric Clark, a young man, was pulled over in his pickup truck in Flagstaff, Arizona, as it were, by Officer Jeffrey Moritz, who was in full uniform. It was a traffic stop. And he was in his police cruiser, and the light on top was flashing. We don't know what happened because only the two of them were there, but we do know from the physical evidence and everything else that Clark assassinated Moritz. Now, Clark suffered from paranoid schizophrenia. That was undoubted. And he had a delusional belief system that space aliens were coming to get him. And he even had wind chimes in his bedroom at home to detect the presence of those space aliens when they came into his room. Now, the prosecution theory of the case was there was bad blood between Moritz and Clark in some way, and it was a traffic stop gone bad, and it had nothing to do with his delusional belief. Clark's claim, however, was he was delusional at the moment. He was charged with the intentional killing of a human being, because Moritz was a human being, obviously, and it was an aggravated form of homicide because knowing he was a police officer, that's a more aggravated form of homicide. And so what Clark claimed was, look, I believed he was a space alien impersonating a police officer. Well, if he really believed that, he didn't intend to kill a human being, and he didn't know it was a police officer. Now, so there's a classic example. And in a state like Kansas, if these events had occurred in Kansas, he could have used his evidence of mental disorder to try to show that he didn't form the intent to kill a human being, knowing that human being was a police officer. All right.
So wait, so in that example,
right,
it's not an insanity defense, it's
No.
actually a way of challenging the prima facie case of the prosecution.
That's exactly right.
Okay.
And notice all he would have to do in that case to win would cast a reasonable doubt on whether or not he intended to kill a human being. And he had very strong and credible evidence, Clark did, in that case. In Kansas, he might have won. But if you go through how homicide is defined, okay, he didn't kill a human being on purpose. He wasn't consciously aware of a risk that this guy was a human being, which is a lesser form of homicide. Well, he was negligent. He made an unreasonable mistake, because a mistake caused by mental disorder is by definition unreasonable. So he'd be guilty of the lowest level of homicide, which is called involuntary manslaughter, basically negligent homicide. Well, I put it to you, he was crazy. He wasn't a careless killer. He was a crazy killer. So that's why that kind of way of allowing mental disorder evidence in really doesn't make any sense. Second of all...
Wait, before a second. So in other words, what you're saying is they shouldn't be blamed
at all.
For anything.
For anything.
Yeah.
And because...
They can't be blamed for anything.
Well, they shouldn't be. Kansas would blame him. They'd blame him if this took place in Kansas. They'd blame him for negligent homicide.
Yes.
But think about who we think about as the negligent killers. People who are really careless, people who are inattentive, but who we believe could have been more careful, could have been more attentive, and the like. So that's why we don't mind punishing them for careless homicide.
And if you believe in deterrence, we want to encourage other people to take greater care.
Exactly right.
Okay.
So this is not a careless killer. This is not an inattentive killer. This is a man who is if we believe him, wildly out of touch with reality. So Kansas wouldn't get the right result, even doing it their way. Moreover, in most cases, mental disorder doesn't prevent a defendant from forming a required mental state like purpose or intent. It gives them a reason to do it. The reason Andrea Yates formed her intent to kill the kids was she wanted to save them from Satan. Mm-hmm. The reason McNaughton tried to assassinate Prime Minister Peel was he thought he needed to do so to save his own life. It was his crazy thinking, his complete out of touch with reality thinking, that caused him to form the law's intent.
Well, I'm also thinking about the police officer killing example. If that was a case tried in Kansas where they would currently under their current law do not allow an insanity defense, but would allow that evidence to disprove the elements of the prosecution's prima facie case, it seems like that could result in a very unintended consequence, which is disproving the prima facie case would result in an acquittal.
Well, he'd be guilty of involuntary manslaughter, at least, because he's so. All right, but if you think about obviously the sentence for involuntary manslaughter varies nationwide, but let's call it somewhere between 4 and 8 years, or 2 and 8 years. So let's assume they threw the book at Clark in Kansas, and he got 8 years. But at 8 years, he's walking out the prison door because there's a maximum term in the criminal law, and there's no way to keep him.
And he may or may not be getting treatment or therapy for his mental disorder.
That's right. And he may still be very, very dangerous.
Yeah.
Now, all you could do at that point, if he was still mentally ill and dangerous, would be to involuntarily, civilly commit Clark. But civil commitment in the United States, even for people who are dangerous, is typically very short term now in the United States. Again, I don't know the Kansas civil commitment statute, but my guess is it's nothing like as bad as these post-insanity acquittal commitments, because the Supreme Court said these are different. The person has been convicted of a crime, has been acquitted by reason of insanity, so they themselves have raised the issue that they're not responsible, and they've been proven to be dangerous because the prosecution has proved the prima facie case of murder, let's say in the case of Yates or McNaughton, and therefore we can hold these people indefinitely. And that could mean for life, at least in principle.
See, that's an interesting thing, because I can imagine the politics in a state like Kansas or any state that would think that this is a good policy to eliminate the insanity defense. I can imagine, as a matter of the politics of the state legislature, that what they think they're actually doing is making a tough on crime policy. But it
is a tough on crime policy in the following sense. And they're right about that, because as I just said, in most cases, even severe mental disorder will not prevent the defendant from forming the intent that the law requires. So therefore, these people are all being convicted and go to prison, all of them. And since so many of these cases are homicide cases, including the case in Kansas that's now before the Supreme Court, people are looking at potentially a life sentence or even the death penalty.
Right. Well, that brings me to the last part of this that I wanted to talk about. And you talk about this in the brief that you wrote for the Supreme Court. There are other cases in related circumstances where the Supreme Court has already deferred to, I don't know if that's the right word, has already taken into account mental disorder or mental incompetence of some kind, or diminished capacity and for some physical, cognitive, or psychological reason in other contexts. So, for example, with regard to the death penalty, I mean, how do you think those prior decisions in those other contexts bear on this?
Well, the Supreme Court recognizes firmly that mental disorder plays a role in a large variety of both criminal and civil law contexts. The Supreme Court says over and over again that psychiatry is an inexact science, and they are going to defer largely to the way the states want to run the mental health law railroad, as it were. So, as for the death penalty, for example, you may not execute someone who even has been properly capitally convicted and capitally sentenced. They may not be executed unless they are competent to be executed. In other words, they understand what the sentence is and why it's being imposed. And some people with severe mental disorder, or given how long this all takes in the United States of America, older, demented capital prisoners may not, when the time comes for their execution, understand. So in this particular case, if the Supreme Court decides that as a matter of fundamental justice, a state needs to have some form of insanity defense, I think they will be very deferential to all the individual jurisdictions, what the nature of, the exact nature of the defense. Whether a state wants to adopt a McNaughton-like test, knowing right from wrong, whether it wants to add an quote-unquote irresistible impulse test or a lack of control test. This will be up to the states. But the Supreme Court has recognized over and over again the influence of mental disorder on many, many legal doctrines.
Well, and usually that comes up as an Eighth Amendment issue, cruel and unusual punishment. Is that the basis here as a constitutional matter for opposing the elimination of the insanity defense?
It's one of them, although I think the basic argument is what's known as substantive due process. And this is a doctrine that is much disputed, but the notion is that there are certain kinds of rights that are so fundamental to our justice system, are so ingrained in our history and tradition, that the Constitution demands them. So, for instance, if you think of the right of marital privacy, going back to the ability of married couples to get contraception and the like, which until Griswold against Connecticut was criminalized,
Right.
The Supreme Court basically said marital privacy is so fundamental that people have this right. And I think, given that we have had some form of insanity defense in Anglo-American law since the 1300s, since every state in the Union and the federal government had it until basically the very late 1970s and early 1980s and into the 90s, and only 4 states have abolished. I think there's a very strong argument. The notion that we shouldn't punish people who don't deserve it is so fundamental to our sense of justice in the United States that this is one of those cases where the Supreme Court should take the extra step, although it doesn't say so in the Constitution, and say, in these United States of America, we simply do not blame and criminally punish people who do not deserve it.
Wow. And this brief has been submitted. Is this case going to be argued?
It's already been argued.
It's been argued.
Yes,
okay.
it was argued the very first case of this term.
Wow. Okay, great.
It was argued first thing, basically 10 a.m. on October 7th. It's a little hard to read from the oral argument transcript, the tea leaves. It seems to me that very strong originalists like Justice Gorsuch and Justice Kavanaugh, who replaced the 2 justices that were on the bench when the court previously decided not to address the constitutionality of the insanity defense. That was a 2013 case from Idaho called Delling. We've replaced Justices Kennedy and Scalia with Gorsuch and Kavanaugh, who are both originalists. And it seems to me the originalists really should want there to be an insanity defense, because it was a feature at the founding of the Republic.
Well, they love to cite English law, so.
And they love to cite English law, right? And but it's very hard to read the tea leaves. In the Delling case in 2013, when the court ducked the issue, and by the way, it ducked it when there were much better facts than in the present case. But the present case facts are good enough. If there had been an insanity defense in Kansas, he had a triable issue. There was enough expert evidence that he would have gone to the jury on the insanity defense. The other case was even more perfect. I don't know why they ducked it in 2013 and took it now. Again, I don't read the tea leaves.
Ducked it meaning they didn't grant cert?
They didn't grant cert.
Oh, I see.
And unusually, there was a written dissent. Usually cert decisions, there's no written.
Right.
And Justice Breyer, writing for himself, Justice Ginsburg, and Justice Sotomayor, said that they should have granted cert in that case.
Interesting.
My colleague Richard Bonney from Virginia and I wrote the law professor's amicus brief in that case too. In that case, we were arguing that the court ought to hear the case, not how it ought to be decided, although it was clear how we thought it ought to be decided. And
just a different stage in the proceeding.
Just different stage in the proceeding, exactly. And Justice Breyer cited the brief. So I'm sure I've got at least 3 justices. Whether we'll pick up 2 more, who knows?
So the so-called liberal justices on the court seem inclined, and what we're uncertain about is how the more these terms have
for
such
want of a better term,
meaning,
conservative justices.
Right, the so-called conservative or more original intent oriented justices, a little more uncertain.
Yeah.
Fascinating.
Actually, I thought from reading the transcript that there was still some confusion about the issues. But the Supreme Court is going to do what the Supreme Court's going to do.
Right.
I assume this is not going to be a case that will take them until the very end of the term. I assume we'll have a decision in this case pretty early in 2020.
Well, we will keep a close eye out for that. Fascinating to work through this and clear up the confusion.
Good, thank you.
Greatly. And what a great pleasure to see you again.
Good pleasure to see you
have
as
you here
well.
in our office. Not just my criminal law professor from first year of Penn Law. We also had a seminar together on the underlying philosophical principles of the criminal law in our country. But leading expert on this topic and a fantastic guest, Professor Stephen Morse. Thank you.
Thank you so much for having me, Aaron.